will, leaves everything to his wife, then gets divorced, and then forgets to do his will?
It depends on the divorce, because very often as part of the divorce process, we will enter into what's called a marital settlement agreement or a separation agreement that provides that the spouses are not to receive anything upon death. And you could probably use that even if there's a will that has not been changed.
But it's a good idea, once again, to do that.
Yes.
Before we forget, I get so engrossed in the conversation, I forget, I want to switch and go back to our other screen so you can see. And if you want to reach Annalisa, there's her website and her email address and her telephone number, which I hopefully have got correct.
Yes.
We had trouble. Your name is nice and long, and so we got it on the screen. But I wanted to do that, and we'll show this a few times. So if you don't get it now, take your pen and pencil out, and you can get it later on. And we're back to the two of us.
All right.
What about children in a situation, and guardians? And that must be a significant. It seems to me a lot of people who did wills do it because they have children and they're concerned that something's going to happen to them. Well, how do you?
Yes.
In a divorce situation, what happens with the guardians' provisions in a wills?
Well, the reality is when you have two parents, the other parent is going to be the priority. So even if you sign a will and name other people as guardian for your child, that's not going to hold up if the other parent is alive and steps in, because in all likelihood they would continue to take care of that child.
Okay.
You certainly want to name other guardians, though, if for some reason something happened to two people. It's less likely after a divorce that something would happen to both, but you always want to name guardians in order to provide for children in case.
What happens? That's an interesting question. I always wondered, if you had a will, the wife has a will naming somebody else as the alternate guardian, the husband has another will naming somebody else, somebody from his family, their family, and then one dies and then the other dies. It's hard for sort of macabre example, but these things do happen. Who gets if they have different guardians in their wills and they're both gone, who gets the kids?
In all likelihood, a judge is going to decide that. Someone is going to apply to become guardian, and the other family is likely to contest it. If something actually happened to both parents, you'd have families from both sides coming in, and a judge would make that decision.
So it wouldn't make. Is there a timing difference on that issue, depending on if
yes, certainly. I mean, if one person died first, and say dad dies and mother's still alive, and then 5 years later mother dies, it's likely her will that's going to take priority, although, again, the other families could certainly come in and try to contest it.
Is there a time frame on that? If it's 5 years versus a month, it just, it's on that one.
No.
Interesting question, which I think comes up in a lot of people with their wills, is how do you deal with leaving money to children in that situation?
You do not leave money directly to children. Anytime you want to provide for children, as most parents do, you provide for children in trust. You either do, if it's a will, you can set up what's called a minor's trust, or if you have a trust, then you set up provisions within your trust. Most people do not want to leave money, first of all, to children under the age of 18, or
I think I know the
they
answer,
stagger it later.
Why would somebody want to do that? I mean, it's maybe obvious to you and I, but it may not be obvious to everybody else.
Several reasons. First of all, if you leave something directly to a child under the age of 18, then a conservatorship is required. For example, if you name a minor as the beneficiary of a life insurance policy, they can't get it. And so a court would have to appoint a conservator. That's someone to manage the money for them until they turn 18. At the age of 18, they would then get that money. Now, most parents don't want their children to get money at 18. They would rather it be held in trust, managed by someone else until they are 25 or 30 or even older sometimes.
Even older. Matter of fact, it reminds me of a quick anecdote. When John F. Kennedy was president, and you read about that, his father, he was president of the United States, but his father didn't trust him to handle the money, and I think his trust didn't expire until he was like 45, and he'd already died at that point, and he was president, but he couldn't touch the money.
Right. Well, and most people do end up doing some type of staggered distribution for children, yes.
What about executors in wills? Again, in a divorce case, I mean, very often I think in a will, it's going to be a spouse that's going to be and I guess that's another strange result too. If you don't change your will, you could have your ex-spouse as the executor.
That's right. Right. In your will, you would name the personal representative or executor under the will, and that's the person that's going to handle distributing assets and managing your estate. And that's a big reason why you also want to update things in the divorce process, because you generally want to name someone else to handle that for you.
Matter of fact, we've mentioned a lot of technical terms here. Once again, I know it's hard in this situation, but maybe you can distinguish between, I always find people get confused between an executor and a trustee.
The difference is in a will, you have a personal representative, or what you're calling an executor. And in a trust, you have a
sorry,
trustee.
but I still, my original background is Connecticut, so I still have some of the Connecticut terms.
Sure. In a trust, you name a trustee. The function is essentially the same. It's someone that you are naming to handle your financial affairs after death, as far as distributing assets or holding them in trust for someone. They do the same function, and generally, if people have both, if you have a will and a trust, you're going to name the same person to act as both the successor trustee and as the personal representative under a will.
That's good. A lot of people own property together,
Yes.
particularly in survivorship accounts. How does that work? And I know, once again, in the divorce context, again, if you
Yes.
have survivorship accounts and you're getting divorced, what happens, or what should you do?
Well, if you do nothing and someone dies during the divorce process, if you have real estate, for example, that's titled in either joint tenancy or community property with right of survivorship, the surviving tenant or the surviving spouse gets everything. They get the whole property.
Unintended result again.
That's right. If you have a bank account or some type of brokerage account where it's held in joint tenancy, then the surviving spouse gets the entire account. So what we recommend is that you sever those types of joint properties. Now, you've got to note that in Arizona, it is probably a technical violation of the preliminary injunction to sever the joint tenancy or community property with right of survivorship, but it's not likely that a court would ever overturn that change in title.
Can you do that if both parties, with a preliminary injunction, can you overrule the preliminary injunctions if both parties agree?
Absolutely.
So it's
Right.
only the unilateral action, but
That's
if both
correct.
parties say we're going to
Right.
change these to separate accounts, it's okay.
Right. But what we have done before is if, for example, it's titled in joint tenancy, we will terminate the joint tenancy and it will be titled in tenants in common. So each spouse still has a 50% interest, but their 50% can then either go according to a will or what we call a beneficiary deed in Arizona.
Let's go over that one again, because a lot of
Okay.
people get incredibly confused over joint tenancy, tenancy in common, and all these legal
Right.
terms, which they perceive as legal mumbo, which are very, very important.
Sure.
Once again, distinguish again for people what the difference
Joint
between.
tenancy is a title where, say, two people own property as joint tenants. If something happens and one of them dies, the survivor gets the entire property. The same is true of community property with right of survivorship. That's a title that can only be held by husbands and wives, but if one dies, the survivor gets the entire property. Tenants in common is a form of title where you can have different percentages, but it also does not pass automatically at death. So if a husband and wife hold it as community property with right of survivorship, and we terminate that, now it's tenants in common. They each still own half, but they can decide what happens to their one half.
We've both seen lots of divorce cases, and I'm trying to think back on how many cases I've seen where people have actually followed this advice. I mean, is that your experience, that people don't do these things and we're sort of just lucky?
Yes, very often people are lucky. I think it's more common that people are taking steps to protect their half of the asset. You're not allowed to dispose of anything or sell it off, but retitling so that you protect your one half
It just seems to me
is a good idea.
People have these huge fights over divorce very often and then ignore something which could just the opposite
Right.
results.
Yes.
All about that. The same thing with life. Another one that comes up is like life insurance, which can be a big number.
Yes.
What should people be doing about estate planning and divorces with that? And if you have any examples,
Well,
we talked a
sure.
little bit beforehand. It's easy to sort of slip into sort of the